In Wisconsin, a judge is setting the final ground rules for the trial of Kyle Rittenhouse. The judge has ruled attorneys cannot refer to those killed as victims.
However, defense attorneys are allowed to call them arsonists or looters. Prosecutors say Kyle Rittenhouse shot and killed two people, injuring a third person during a protest over police brutality in Kenosha. Now, last August is when that happened, and he's arguing that he acted in self-defense. Joining us today with more on why the judge made this decision and how it could impact the trial is Lance Northcutt. He is an attorney at Salvi, Schostok, and Pritchard. Thank you for coming on.
Thank you for having me.
Okay, so why do you think the judge would make a decision like this? Were you surprised?
I was very surprised at the way in which the decision came down, specifically in a manner that really hurts the prosecution and enables the defense to essentially demonize the people who were victimized in this case, the people who were shot.
Let me ask you this. I was reading a quote from a law professor at the University of Wisconsin, Lance, and here's what he said. He said, in any self-defense case, the people who were shot are also on trial. If you think about it, it does sort of make sense, does it not?
Well, it makes sense from that perspective as far as a defense theory. But as a matter of law, to suggest that somehow a prosecutor would be enjoined from advocacy, from referring to victims as victims, seems to be a bridge too far. And there have been situations where courts have ruled that this type of constraint on a prosecutor's speech in front of the jury is proper. But the vast majority of cases in courts across the country will allow prosecutors a fairly wide latitude in explaining the evidence in a way that they believe is supported by the facts. And here you have kind of a unique situation where the judge has come down and said, we don't want to have a pejorative used in describing the victim, but we will allow the defense to describe the victim as a looter or a rioter. And there's a logical inconsistency in that, it seems to me. If you're going to suggest that somehow the prosecution is going to be barred from characterizing a person who was shot in any one way, you have to be consistent across the board with respect to the defense. It seems like the defense kind of got an advantage here.
Is there any way to get around this? I mean, like when you're in court, yeah, you can't call them victims, and you can, refer to them as the arsonists or looters, which you wouldn't want to do if you're obviously the prosecutor. But if you're the prosecutor, can you get around this by saying the name of the victim and constantly putting that name out there to humanize the victim?
You can, and sometimes prosecutors will call the victim by their first name, but in terms of describing the action, it puts them at a disadvantage in not being able to characterize them as the victim, because how do you otherwise describe them? Before you introduce them as people with names, you have to set the stage as to where they fall into the story. And to just say, well, these are the people who were shot, it gives kind of an awkward rhetorical block as far as what the prosecutors can argue. One that, as a former prosecutor, I would not have wanted to see in any courtroom.
Well, semantics will be certainly at play inside that courtroom. Lance Northcutt, attorney at Salvi, Schostok, and Pritchard. Thank you so much for your insights this morning.
Thank you for having me.
All right, 8:10.